Okay, so that was the prosecutor reading Officer Gaffney's testimony before a grand jury, or the parts that he thought were important. And he actually indicated some of them. I'd like to bring my guest in, Lisa Wells from Atlanta, Georgia. How are you?
Good. How are you doing?
Now, you have prosecuted cases in the past. You now defend cases. Just in terms of the prosecution tone, I know that a lot of our viewers were there in the chat room. They were a little bored at the reading of a transcript. Have you ever had a transcript read?
You know, I have not personally in a trial. I've heard one read before.
And it seems to me he could have made a bigger deal out of this. I know that when he got to certain parts, he said that you felt you never felt at risk, and he kind of raised his voice. Wouldn't it have been more effective to have somebody read different parts and put some emotion into those parts he felt that were important?
Yeah, it does seem that, you know, because that's such an important part. I mean, that is critical, that he never felt at risk at all. Okay. He was in the protection of his vehicle, as he stated.
Yeah, that's really good. We're going to talk more about it. I had to interrupt you because we're going right back into court. Defense attorney is speaking right now. Just heard Mr. Pugh, the attorney Pugh, arguing for Joseph Walsh. Now, we were a little bit confused here, and I'd like to bring Lisa Wells in to help discuss this with us, because it first sounded like Mr. Pugh was arguing for a judgment of acquittal for his client, right? Didn't you get that effect, Lisa? Right? That he should have proven the case, right?
It was very powerful as well.
Right,
he was doing
but what he was doing was arguing that the emails and the hearsay transcript of Gaffney should not be used against his client because they haven't proven, the prosecution hasn't proven even a bona fide case, nonetheless a prima facie case, against his client. So it seemed to me he was combining a judgment of acquittal with a motion argument. I thought it was fabulous. How about you, Lisa?
Oh my gosh, it was great. I think he did an amazing job. And you know, going back to what we just heard too, them reading the transcript, they haven't shown that these guys, you know, had a conversation with each other. So and then he just brought it home. It was great.
That's great. All right, we're going to go right back in the courtroom because Mr. McKay, as you know, has been one of the forceful lawyers in this case. He is now arguing before the judge. Let's see what he's saying. Okay, so what you're hearing now is the prosecution, and I know when the defense spoke before objecting to the emails and some of Gaffney's transcript, it sounded like a summation or a judgment of acquittal motion. The prosecution almost sounds like it's doing a summation. It's arguing that indeed these emails and all need to come in because we have already shown, that means the prosecution has already shown that the statements made by the defendants, of various defendants, were untrue. That is that Laquan McDonald raised a knife and pointed it at Van Dyke. That is that there was there was a constant barrage by, even after the firing of the gun at McDonald, he tried to get up and go at the officers. That is that after the firing of the weapon, McDonald continued to try to plunge the knife at them. So what the prosecution is saying, that all of these agreements were made to say this, that each officer at some point made an agreement with each other to say these various untrue things. They sent them to March put them in some type of format, and they all agreed and no one came forward to correct them, and therefore that is a conspiracy. So let's hear what else. What are the delineations? When I mean he's saying delineations, he's listing exactly what the officers may have said that is untrue that led to a conspiracy. Well, this is the prosecutor again detailing all the statements, and we got a little bit of a glimpse, Lisa Wells, into the fact that apparently there's an email from a subordinate of Detective March, which made the summary conclusions in the report that all the other officers had agreed to, and that's why these emails may be so devastating and being objectionable. Look, they've got me all crazy here today with them. Now, I was always taught. Now, excuse my, but I don't know if you can see this. This is like a bicycle spoke, you know. In a conspiracy, that spoke one doesn't have to know what spoke two is talking about, as long as they're going to agree to meet in that middle, even if it's just by a nod and a wink. What say you about whether the prosecution is proving this right now?
You know, I mean, it can so be argued both ways. The thing is that they have to show that these guys did indeed intend to commit this conspiracy, that they were trying to further this. And I unfortunately see every day as a defense attorney cut and paste police reports. I mean, this one shouldn't have been that way, but exaggerations of what happened. And, and the prosecutors go with it. Why? Because it's furthering what they're trying to prosecute. In this case, they don't like it because now they're trying to prosecute the guys that did that.
Well, you make a good point that there has to be a policy from above or some kind of practice of monitoring, and then if a police officer makes a statement that's untrue, even if it hurts the prosecution case, really it starts with the prosecutors to come down at that point, right?
Right, exactly. And, and it's sad that there's so many wonderful prosecutors and so many wonderful police officers out there, but some sloppy ones really, show that it exposes there's way too much of it out there, honestly.
Yeah, you're so right. Well, we're going to continue to cover this case. We have to take a short break. Stay with us. We'll be back on the other side. Well, so we're continuing argument. This is Mr. McKay. As you know, he has been the most animated of the lawyers in this trial. Now, what did we hear? We kind of heard a shot over the bow, Lisa Wells, when Mr. Pugh, on behalf of the defendant Walsh, got up and said the prosecutor, and I'll repeat it, doesn't understand the rule. I mean, you're talking about a prosecutor who's very detailed, and he said, you don't understand the rule. You just don't understand the law. Do you think the judge is paying attention to that, or is she paying attention to whether or not the prosecution has proven by inference some kind of understanding between all these gentlemen, I will call them police officers, that there was an agreement to cover up the shooting?
Well, I thought that, again, Pugh made an excellent point when he said, what they're trying to do is offer hearsay of one person and attribute it to another person in order to make that person, to convict that person of conspiracy.
But isn't that what a conspiracy allows? Hearsay against some co-defendant to say the other co-defendant is guilty? Isn't that why prosecutors, and we used to both be one, love the conspiracy trials?
Well, the thing is that if one person has no idea that that there's a conversation going on between the other two, and they haven't proven that they're doing something in furtherance of a conspiracy, but luckily that's what a jury may be saying. But a judge, I mean, she kind of knows what she's doing. She's been around for at least 10 years, and before that, she was a state's attorney in Chicago. Now, one of the other things we had was that these emails, it turns out we were right, that Wojak actually was a superior to March and wrote the final report, which really said, hey, this was basically a good shooting and trying to cover it up. And so the argument is that the superiors here in these emails, along with somebody who then later was part of the union, who later worked with the legal defense team in some way, may have formulated this whole plan, and with a wink and a nod, this is what you guys are going to say. What do you think how do you think that comes across right now? I mean, it does create some, there are some things that are so far off from what actually happened that you think surely, it is very suspicious.
Well, Lisa, we'll have to continue this discussion another day. The problem is everybody in Chicago knows there's been corruption in the Chicago Police Department. They have revamped it, but even the judge knows about the problems of excessive force in this police department. So that's really why a conspiracy may be believable if you have the history or the understanding. But here at Law&Crime, we're going to continue to cover this case because it's so fascinating, so interesting. Right now, Aaron Keller will be back in the Daily Debrief. I'm Linda Kenney Baden. I will be back next week, 3 to 5. Stay tuned.